Hey, good morning, everyone. Good afternoon, depending on where you are. My name is Jamie Crook. My pronouns are she, her. I'm a senior staff attorney at the ACLU of Northern California, and I'm part of the Bay Area Lawyers Chapter for ACS. And our co-sponsors are the Los Angeles chapter, the San Diego chapter, and also the At-Large chapter. So we're glad you're all here to talk about homelessness and the COVID pandemic today. We'll be hearing from one of the lawyers who litigated the landmark Martin versus Boise case, in which the Ninth Circuit held that governments cannot criminalize conduct that is the unavoidable consequence of being unhoused if the government cannot provide accessible indoor shelter. And we'll hear about how Martin interacts with the realities of shelter accessibility before and during the COVID pandemic. And then we'll hear about legal issues facing local jurisdictions concerning unsheltered populations right now in this current health crisis. Just a little note on terminology. I will use the term unhoused, and I believe panelists will as well, to mean anyone experiencing any form of homelessness. So whether that's living in a shelter, family member's couch, outdoors, in a vehicle. Unsheltered is a subset of unhoused, and that will be used to refer to people whose primary nighttime space for sleep is not made for human habitation. So encampments, people living on the streets, in vehicles. We'll focus today, the issues that we'll talk about today have nationwide application, but we will be using examples mostly from California. California has more than 150,000 unhoused people, and the COVID-19 pandemic has compelled local and state government officials here to move away from a criminalization approach to homelessness and towards a more rapid effort to provide shelter. That's been a process that governments are figuring out as we go, and we'll hear about what some of those challenges have been and ways that we could move people in more quickly, and also what it means to suddenly provide shelter to thousands of people who previously didn't have it, and what we do with that after the health crisis subsides. I think with that, I will introduce our panelists and turn it over. One note before we get going, there is a Q&A box that you'll all see at the bottom of your screens. We'll take some time for questions at the end. You're welcome to submit questions at any point, but I'll probably hold them until the three panelists have gone through their presentations. So with that, I'll introduce our panelists. We'll start with Tristia Bauman. Her pronouns are she, her. She is a senior attorney at the National Law Center on Homelessness and Poverty. She combines litigation, legal education, and legislative advocacy strategies to prevent and end homelessness. Her work focuses on combating the criminalization of homelessness and advocating for laws that protect the civil and human rights of homeless people. She conducts legal trainings around the country, writes reports and other publications related to housing, and serves as a legal resource for homeless advocates. Tristia began her legal career at Legal Services of Greater Miami as a housing attorney working with low-income tenants in federally subsidized housing. She later served for several years and as assistant public defender in Miami-Dade County. Tristia attended the University of Washington as an undergraduate and law student, and we will turn it over to her to start us off with some overview on Martin versus Boise.
Thank you, Jamie. Hello, everyone. I am going to attempt to share my screen. I just did this successfully, and I think that the Zoom bar is covering what I need. Here we go. Welcome. Again, my name is Tristia Bauman. I'm a senior attorney at the National Law Center on Homelessness and Poverty. We are based in Washington, D.C. I work remotely out of San Jose, California. The Law Center is the only national legal organization whose sole mission is to prevent and end homelessness using the power of the law. And one of the strategies that we use to achieve that mission is impact litigation. One of the cases that we litigated is Martin v. City of Boise, which I will talk about in a moment. But before I do that, I want to mention some other work that we do and provide some context as to why the Martin case is so important. So some background on the causes of homelessness. I'm going to go quickly through these intro slides. They will be available if you would like to refer back to them. So don't be concerned if I skip over some of the bullet points. You'll be able to refer to them later. But a primary cause of homelessness is a lack of housing that's affordable to the poorest Americans. There is a significant disconnect between prevailing wages and the rising cost of housing. And today, there is not a single location throughout the United States where somebody working full-time earning the federal minimum wage can afford a one-bedroom rental unit. In fact, somebody would have to work the equivalent of 2.5 full-time jobs at the federal minimum wage to afford a one-bedroom rental unit at market rates. There is a significant affordable housing gap where there are only 35 units that are affordable and available for every 100 extremely poor renter households. And extremely poor renter households means households earning 30% or less of the area median income. In addition to affordability issues, racist housing policies and practices like redlining and discriminatory rental admission policies have contributed to the problem of homelessness, and in particular, racial disproportionality in the unhoused population. And today, some 60% of unhoused people are people of color. Once housing is lost, it becomes difficult to impossible to meet your basic human needs for things like shelter and a safe place to rest. And this is due in part to the fact that it is illegal to rest in most US cities. As part of the Law Center's work, we have since 2006 done periodic surveys of a core set of 187 cities across the country. These are cities large and small, urban and rural, really in every corner of the United States, and looked to see what laws are on its books that punish life-sustaining activities of people that lack housing. I'm going to go over a couple of the statistics here just to paint the picture of how difficult it is to lawfully rest and how it's impossible in the majority of the country. 72% of our 187 surveyed cities have restrictions on camping in public. And of that 72%, 37% of those ban camping citywide, meaning on all public property. And of those, 9% ban camping not only on public land, but also on private land, leaving literally no place where someone can camp. Sometimes when we think about camping, we think about erecting tents, but camping bans are written really broadly to include merely sleeping outside or resting outside, as was the case in Boise, Idaho, or even just using tents, blankets, laying down a piece of cardboard, or just resting next to your property. There are also sleeping bans. Ooh, skipped ahead. Sleeping bans. Sleeping is a universal and unavoidable action. No one can resist the biological need to sleep, yet over half of surveyed cities prohibit sleeping outside, and 21% of those prohibit that activity citywide, meaning in all public spaces. There are also bans on other forms of rest, for example, sitting and lying bans, and over half, 55% of cities restrict those resting activities. 7% of those surveyed cities restrict sitting or lying down anywhere in public space. Obviously, if you are a person who lacks a private place to rest, you will inevitably rest in outdoor public space, and in the majority of the country, you'll be subject to punishment. Enforcement of the laws takes a number of different forms. Today, we're going to be focusing on criminal punishments, but that's not the only type of punishment that people face. And I've listed the way that enforcement plays out and the harms that people suffer as a result of enforcement. But the Martin case focuses on criminal punishment, and it's important that we recognize the disparate impact that these laws have on people entering into jail systems. People without housing are 11 times more likely than housed people to go to jail. And in some communities, like in Portland, Oregon, for example, in 2017, half of people booked into the local jail were people experiencing homelessness. The criminalization of homelessness has a lot of harmful impacts. One, it worsens the homelessness crisis. Convictions can make somebody ineligible for subsidized housing. A lot of people don't realize that, but public housing authorities have the ability to determine their local admission policies, and it is not uncommon for even misdemeanor convictions and even old misdemeanor convictions to serve as an absolute bar to obtaining subsidized housing. Also, people who have convictions on their record may be passed over for private rental housing, especially in competitive markets. There are other harmful impacts of criminalization policies, including harms to public health, which are very relevant today. And you can read all about the growth of laws criminalizing homelessness and their harmful impacts in our report, Housing Not Handcuffs 2019, that includes the analysis of laws in the 187 cities that we've been studying for the past 14 years. It also has a section on legal challenges to criminalization policies. The Eighth Amendment is one tool that has been successfully used, but it's not the only tool. And you can see more about that, as I said, in the Housing Not Handcuffs 2019 report, available on the Law Center's website. Also, you can check out our Housing Not Handcuffs litigation manual. But we're here today to talk about Martin v. City of Boise. The Martin case was originally filed as Bell v. Boise, and it was filed on behalf of 6 homeless individuals in 2009 against the city of Boise. In Boise, there are essentially 3 shelters offered by 2 different providers. The first is offered by Interfaith Sanctuary Housing Services, referred to as Sanctuary. It has 96 beds for individual men and women, some beds reserved for families, and some space on floor mats. They are frequently full. In fact, in 2010, Sanctuary reached full capacity in the men's area at least half of every month, and in the women's area, almost every single day of a given month. The other 2 shelters are operated by the Boise Rescue Mission, which is a Christian nonprofit organization. One of the shelters, River of Life, is available exclusively to men. The other, City Light Home, is available to women and children. The rescue mission shelters are available for limited periods of time, meaning you get essentially 17 nights in the shelter, and there's some other restrictions. You have to be there by 4:30, you have to use it regularly, and then after you have complied with the rules and been in the facility for 17 nights, then you're not eligible to return for a period of 30 days unless you enter into what's called the discipleship program, which is described by the program as an intensive Christ-based residential recovery program. And I mentioned that because it will be relevant to why shelters, even if there is an open bed, may not have an accessible bed for the individual who needs it and who is otherwise subject to penalty. The Martin case has a long procedural history. I will spare you the details, but suffice it to say that it went up to the Ninth Circuit twice on procedural matters. The second time, the plaintiffs invited the Ninth Circuit to opine on the merits, and the Ninth Circuit took that invitation, and on September 4th, 2018, the Ninth Circuit found and affirmed that the state may not criminalize conduct that is an unavoidable consequence of being homeless, namely sitting, lying, or sleeping on the streets when there are more homeless people than available shelter beds or in the absence of other adequate alternatives. That was the first Martin decision, and there was another opinion that came from the Ninth Circuit after the city of Boise sought rehearing en banc of that decision that we just mentioned. But before I talk about the final Martin decision, I want to talk a little bit about the Eighth Amendment and cruel and unusual punishment claims. The Eighth Amendment of the U.S. Constitution states that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. There's a U.S. Supreme Court case, Ingram v. Wright, that talks about the cruel and unusual punishment language of the Eighth Amendment and holds that the Eighth Amendment circumscribes punishment in three ways. It affects what type of punishment can be handed out pursuant to criminal activity. It prohibits grossly disproportionate punishment, and it also circumscribes what can be made criminal and punished as such. And the majority of courts that look at the line of cases that Martin relies upon look at that third prong: what can be punished as criminal. The Martin case rests upon two Supreme Court cases. The first is Robinson v. California, that challenged a law making it illegal to be addicted to narcotics. The U.S. Supreme Court found that law was unconstitutional because it punished status in violation of the Eighth Amendment. You cannot be punished for being a person of a particular status, or at least criminally punished for being somebody of a particular status. Building off of that precedent, sorry, I keep on touching the wrong buttons here. Building off of that precedent, the Supreme Court applied Robinson in the context of a Texas law that made it unlawful to be drunk in public. And what the court ultimately found is that conduct that is inseparable from status and impossible to avoid also may not be constitutionally punished under the Eighth Amendment. Now, the Powell decision is not an example of the Supreme Court's best work, we can say. The four-justice plurality voted to affirm the individual's conviction and distinguished Robinson on the ground that the Texas statute made criminal activity and conduct the subject of punishment, not the status of being an alcoholic who goes into public. And the decisive fifth vote, which was cast by Justice White, cautioned that an individual who could show it was impossible to avoid conduct resulting from a status was protected by Robinson. And so while Justice White agreed with the result in the case, the rationale and the combined with the dissenting opinion established the principle that conduct inseparable from status and punished is akin to punishing status itself. So again, interesting procedural history that resulted in the Martin decision. The final Martin opinion is the one that was issued on April 1st of 2019 by the Ninth Circuit after it denied Boise's petition for rehearing en banc. And I've given the citation to the case here. I'll just go over a couple of key points with respect to that holding. Following from the Robinson and Powell line of cases, what the Martin case essentially holds is that universal, unavoidable conduct, in this instance, sleeping, sitting, or lying down outside, performed involuntarily in public space, meaning performed by a person who lacks housing or any realistic access to shelter, cannot be criminally punished, because punishing that activity is akin to punishing the status of homelessness itself, which is unlawful under the Eighth Amendment. I've quoted here from the Martin opinion, and I'll just note that one of the guiding principles in the Martin case is set forth here. Whether some other ordinance is consistent with the Eighth Amendment will depend, as here, on whether it punishes a person for lacking the means to live out the universal and unavoidable consequences of being human in a way that the ordinance prescribes. The court talks in a number of places about how the Martin decision does not require governments to establish shelter for people, but to the extent that someone does not have access to shelter as an alternative to public space, and they are criminally punished merely for arresting activity, then an Eighth Amendment violation would lie. However, there is no unfunded mandate in the Martin decision. Governments are not required to do anything other than to refrain from criminally punishing people for mere resting activities when they are unhoused and lack any indoor and lawful location where they can perform those resting activities. Shelter availability, and really, I guess more appropriately described as accessibility in light of Martin, is an open question. And you'll hear more about what it means to be accessible under Martin from the next speaker, Tom Zito. But a couple things that I want to mention. Again, open beds do not mean available beds. A defense that cities often raise is, well, the shelters have never reported as full. That is a fact that was before the court in the Boise case. The rescue missions shelter never reported itself as full, pursuant to a policy, excuse me, that it had not to turn people away. It said it would always find, some space to, to throw down a mat, even if it's in a hallway or in the cooking area. They would take somebody in under their roof. However, what the court examined are other reasons, despite the technical availability of a bed, why that bed may not be available to the individual who is subject to penalty. For example, in the Martin case, one of the plaintiffs had met his 17-day stay limitation and was excluded pursuant to the shelter's policy from re-entering for a period of 30 days. Even if there's an open bed during that 30-day period, it's not available to him. Also, another of the plaintiffs is not Christian and objected on First Amendment grounds to being essentially forced after the 17-day period into a Christian discipleship program in order to retain shelter. What the court found is that that type of pervasive religious requirement that might conflict with someone's religious beliefs could not be deemed an available space for purposes of Eighth Amendment analysis for that person. You're not required to trade your First Amendment right in order to avoid being punished. So, as I said, you'll hear more about the accessibility, availability questions, but I'll just go quickly to the COVID-19 crisis and what that means. Unhoused people are at increased risk of hospitalization, serious illness, and or death. That is always the case. Unhoused people are up to 5 times more likely to be hospitalized in a given year than members of the general population. And that's because homelessness is very hard on the body. It adds 10 to 20 years to a person, and there are higher incidences of early death and also higher rates of chronic health conditions, including health conditions that are COVID-19 risk factors. Key prevention measures to curb the spread of COVID-19 are things like sheltering in place, maintaining physical distancing, utilizing hand washing and hygiene facilities. All of these things are difficult to impossible for an unhoused person to comply with because there are literally more human beings than private indoor spaces available to them, and congregate shelter facilities are also unavailable, typically full, and even where they are available may not be safe options, particularly in the COVID-19, during the COVID-19 pandemic. As a result, homeless individuals are projected to be hospitalized, require critical care, and to die at higher rates from COVID-19 than members of the general population. And this is a problem not only for the unhoused community, but for entire communities, because every hospital bed that is utilized by an unhoused person because they did not have access to a safe place either to manage their chronic conditions and avoid the increased risk of hospitalization that they always face, or because they're unable to follow best practices to curb the spread of COVID-19 and become infected from that disease, all mean fewer resources available to members of the general public, and it also increases the risk that members of the general public will become infected. There is CDC guidance that has been offered both with respect to indoor shelter facilities. Most recently, there have been at least 2 guidances with respect to sheltered populations. The most recent guidance has made even stricter the conditions inside a shelter to minimally protect people who are living there. One thing that I'll note about CDC guidance is, in addition to what you see here, the latest shelter guidance talks about things that must happen inside a shelter to even have a chance of being safe, like everyone has to wear masks, there should be physical barriers between beds, people should be physically spaced between beds and also physically spaced at meal times. What advocates and people experiencing homelessness know is that that guidance, while well-intentioned, really is not practicable. Inside shelters, people will move around. They're going to use shared facilities like shared bathrooms and come into contact with shared surfaces. And we know that the virus can live on certain surfaces for as much as 3 days. There's growing evidence that it may even aerosolize such that it just remains in the air in some of those shared spaces. Recognizing that the shelter facility, while still technically available as an option under CDC guidance, the CDC has also issued other guidance with respect to people who are unsheltered, that subpopulation that Jamie mentioned at the top of the call. And for those, the CDC states that encampments should not be broken up unless there are individual housing units made available to those folks. And that's an implicit recognition of the increased risks inside of congregate shelter facilities. Obviously, and here's a little bit more about the guidance. You can find this guidance on our website and also, of course, at the CDC's website. The Law Center has a Housing Not Handcuffs campaign. You've got my contact information. I'll move quickly over that because I know I'm a bit over time, but I just wanted to say that the issue of shelter accessibility and the health risks inside of shelter during the COVID-19 pandemic are matters of great concern, both for public health and also implicate the Martin decision. What does an accessible bed look like during the COVID-19 pandemic? And with that, I turn it over to the next speaker.
Great, thank you so much, Tristia. And I know that people have some follow-up questions for you, so we'll get there at the end. But now we'll move on to Tom Zito. His pronouns are he, his. He's a supervising attorney at Disability Rights Advocates, which is a nationwide organization. Tom is based here in the Bay Area. Before joining Disability Rights Advocates, he was a senior attorney with the Fair Housing Law Project and the public interest law firm of the Law Foundation of Silicon Valley. At the Law Foundation, Tom litigated individual and class action housing discrimination cases, as well as cases involving issues of affordable housing, predatory habitability, and tenants' rights in state and federal court, and engaged in state and local municipal advocacy around issues of housing discrimination and affordable housing. And before joining the Law Foundation, he worked as a litigation associate at a small public interest law firm in Massachusetts, where he represented tenants, employees, and consumers in housing, employment, civil rights, and consumer protection cases in state and federal courts. He graduated from Northeastern University School of Law and the University of California, San Diego, and we'll turn it over to Tom.
Thanks, Jamie. I have to unmute myself.
Yeah, we can hear you.
Okay, just setting up my screen sharing. Can you see the slides? I lost my Zoom link right now.
Yeah, we can see your slides.
Okay, thanks y'all. So my name is Tom Zito. I work for Disability Rights Advocates. We're a national nonprofit disability rights legal center. We have offices in Berkeley and New York. Our mission is to advance the equal rights and opportunities for people with all types of disabilities. Our principal tools in that endeavor are impact and class action litigation. So I'm going to discuss a little bit about how the Martin case has applied to unhoused people with disabilities and what some of the implications are. So there's some specific issues for unhoused people with disabilities. As Tristia described, generally, people face a barrier to shelter that, and she went over the general barriers that most people face. People with disabilities face an increased barrier to typical shelter placements. Significant numbers of unhoused people are people with disabilities. For example, in Santa Clara County, about 42% of unhoused people have some sort of mobility disability, and over 50% identify as having a mental health disability of some kind. These are just examples, and each jurisdiction is different. Many of these numbers are actually higher, especially people with mental health disabilities. That's probably a significant undercounting. What's most important is what constitutes available shelter for people with disabilities may or may not be different from people who do not have disabilities. And then I also want to discuss a little bit about how the COVID-19 pandemic affects people with disabilities specifically in the shelter context. So barriers to shelter faced by people with disabilities. Tristia went over some of the general barriers that people face. In addition to those barriers, here's some example of kind of some typical barriers to congregate shelter living faced by people with disabilities. For people with mobility disabilities, this includes like lack of accessible entry, ingress, egress. For example, shelters have steps or other barriers. Pathways are inaccessible, narrow rows between cots and beds, narrow doorways, narrow hallways, things that are inaccessible to people using wheelchairs or other forms of mobility assistive devices. Often shelters have cots on a floor, which are difficult for people or inaccessible in many cases, or sometimes they have bunks. There's often prohibitions of bringing in certain devices. Sometimes people have to leave things at the door. Bathrooms are often inaccessible, as are showers and other places to clean themselves. For people with sensory disabilities, there's sometimes prohibition on service animals, poor layouts, no architectural elements, lack of sign language interpreters are often present in shelters. For people with mental health disabilities, there's, again, the prohibition on assistive and emotional support animals. There's people who have suffered trauma or personal violence often will not want to sleep in large common rooms, especially those where there's mixed genders. They need private space. Some of them have been thrown out of shelters for, quote unquote, behavioral problems related to directly related to their disabilities. Some shelters have prohibitions on medications or seize your medication and want to keep it locked while you're there. And there's other kind of typical issues living in congregate settings. And immunocompromised individuals are going to be more susceptible to illness and disease. In addition to that, the other, like some shelters have work requirements, which are not possible for people who cannot work because of their disability. So these are just, examples of what some of the additional barriers that people with disabilities may face going into congregate shelters or being forced into congregate shelter, which is kind of the definition of what is an available shelter. So what does that mean? What does available shelter mean for people with disabilities? So what I think it's important to look at what Martin prohibits, and this is from Judge Berzon's concurrence. Importantly, the Eighth Amendment in Martin makes unconstitutional sleeping, sitting, or lying in all public spaces when no alternative sleeping space is available. So, since nothing in this opinion reaches beyond criminalizing the biological essential need to sleep when there's no available shelter. So you have to kind of focus on what is available shelter and what that means. Which is not completely clear from the opinion. Specifically, Judge Berzon says, someone can't choose not to go to a shelter bed if it's available to them. They have to basically have no option. And then also she discusses, whether some other ordinance is consistent with the Eighth Amendment will depend, as here, on whether it punishes a person for lacking the means to live out the universal and unavoidable consequences of being human. Well, what does that mean? You know, and what is this? I think kind of her opinion gives us, you know, it brings more questions than answers. And how does this apply to people with disabilities? So, so what are the universal and unavoidable consequences of being human? Is having a disability part of that? And what does that mean? I think, you know, we would answer categorically yes. So if that's the case, under disability rights laws, institutions, shelters, private institutions, public institutions are supposed to make reasonable modifications and accommodations to their policies and to prevent discrimination. So how does, this is under, I'll get into the law in a second, but you know, this is under statutory law, and how does this intersect with the Eighth Amendment prohibitions of Martin, and how, again, does the COVID pandemic complicate all of this and complicate municipal and state reactions to the pandemic and the crisis of people living unsheltered and unhoused. So in terms of statutory law that protects people with disabilities in the unhoused context, Title II of the Americans with Disabilities Act does. That applies to states, counties, municipalities, and any municipal or county program or shelter that would be directly run by a county or municipality. Section 504 of the Rehabilitation Act applies to all federally funded entities. That can include private entities that receive federal funding. Title III of the Americans with Disabilities Act would apply to private places of public accommodation. That's most commonly applied to nonprofits that may run a shelter or own a shelter. And in some cases, the Fair Housing Amendments Act can apply to some shelter, but mostly that's long-term shelter spaces. California state analogs, at least for those of you in California, include Government Code 11-11135, which is the state analog to Section 504, so state-funded entities. The UNRU Act, under Civil Rights Act, which is California Civil Code 51, and the California Disabled Persons Act, which is California Civil Code 54.1, 54.2, and 54.3. And in some cases, the Fair Employment and Housing Act would apply. So how do these disability rights laws apply in the context of shelter? So under the ADA, discrimination, and this is in the public context, but also applies in the private context, is an entity's failure to reasonably modify its policies, practices, or procedures when such modifications are necessary to avoid discrimination on the basis of disability. Importantly, the Ninth Circuit has found that, you know, a plaintiff doesn't need to allege either disparate treatment or disparate impact in order to state a reasonable accommodation claim, just that there is a facially neutral requirement that's consistently enforced even when reasonable accommodations are necessary to level the playing field. So the need for reasonable accommodations under different, this is the ADA Title II, but under Title III, Section 504, or the Fair Housing Act, this analysis is similar. And under state law, it is also similar. It's, you know, whether or not a facially neutral law imposes a disproportionate burden on a person with a disability. So with that, the typical, we went over some of the barriers in shelters. So the typical reasonable accommodations that are requested in shelters that can be more easily granted are accommodations to no pet policies. Service animals, they generally have to be allowed under federal and California law. They can't be prohibited. These apply to dogs, or only dogs and miniature horses. Emotional support animals should be allowed under a reasonable accommodation under state and federal law. There's often cited problems with conflicting residents' allergies to dogs or cats or other animals. There are, you know, so that there are other issues, and the animal issues is kind of endless. I don't want to go too far into that. Other issues and policies, interpreters, private rooms, behavioral policies, kind of so-called second chance. People should be allowed reentry because of mental health related behavior. These are relatively easy. Depending on private rooms can be trickier, and interpreters can cost money, but these are relatively easy accommodations that can be provided in shelters. The issues that are most often not able to be accommodated by shelters are physical accessibility elements, sometimes again private rooms and spacing, and additional sensory accommodations. So there's problems with the seeking accommodations in shelter at the point of when we're talking about enforcement and whether or not a shelter is accessible. Usually an accommodation request needs to be made, and at the time of the enforcement by any particular municipal entity, the person with the disability may or may not know whether that particular shelter has a barrier for the person against who's being swept or is being asked to go to shelter to get off the street. And then in order to get the accommodation, sometimes invasive personal information is going to have to be disclosed to the municipal officer who's enforcing a no-sit, lie ordinance, no camping ordinance, or disclosed to the shelter. And it's not always kept private by the shelter. So what does that mean? If a shelter is inaccessible, no accommodation is granted, is it available? Martin would seem to say no, but this hasn't been tested. A municipality has a duty. We do know that a municipality has a duty to accommodate and modify its enforcement policies and not enforce if it knows a shelter is inaccessible. So McGarry versus the city of Portland would be the case on point in the Ninth Circuit. That involved a nuisance ordinance that was being enforced against a person with a disability to clean up their yard, and they needed more time to do it and more assistance to do it. And the city started ticketing and essentially criminalized the behavior. And the Ninth Circuit said, no, the city has to accommodate its policies and not affect discrimination on the person with disability. So that would lead one to think that that at least under Martin, that if the municipality knows that a person will need an accommodation or makes clear that they will need an accommodation or cannot go to a shelter because the shelter is inaccessible to them within the meaning of the ADA, that they will need to accommodate, they will need to either not enforce and allow that person to stay or find some other shelter that might be available to them before enforcing. So what does COVID-19 do to all of this? As Tristia detailed, people who are unhoused are a much more vulnerable population. They have less access to sanitation, to hand washing and sanitation. They're more likely to have underlying health issues, more likely to require hospitalization, have decreased lifespans, and generally have more health issues. Congregate shelters are not great places for people who are vulnerable, and people with disabilities are even more particularly vulnerable, given kind of the necessary proximity, group settings, etc. So I guess the question for us and for this group is, does the presence of COVID-19 make accommodations to enforcement even more necessary? And some cities are doing that, and some cities are not. Some are not enforcing, some are. But I think that's a question. And under the ADA and requirements of disability rights law, the answer would be yes. So that was very quick. Here's my contact information, and I'll look forward to answering questions.
Great. Thank you so much, Tom. And we are getting some questions in. So everyone, please keep sending them. If possible, use the Q&A button at the bottom instead of the chat. That way we can keep track of them and which ones we've answered. And we'll save them till the end, but you can go ahead and submit them now so that we've got them ready to go. And so we'll turn over to our third panelist, Zoe Savitsky. Pronouns are she, hers. She's a deputy city attorney in the Oakland City Attorney's Office, where she represents the city in litigation, provides legal advice to city staff, and engages in other forms of legal advocacy on behalf of Oakland. Before joining the city attorney's office, she was deputy legal director at the Southern Poverty Law Center, where she led the Southern Poverty Law Center's children's rights work in Alabama, Florida, Louisiana, Mississippi, and nationally. And in that role, she oversaw integrated advocacy campaigns regionally and nationally, focused on stopping the school to prison pipeline, fighting for educational equity, protecting children's access to health and mental health services, and responding to children's rights crises. And before that, Ms. Savitsky was a trial attorney in the Educational Opportunity Section of the Civil Rights Division of the United States Department of Justice. And while at DOJ, she investigated, litigated, and resolved civil rights cases in jurisdictions across the country, especially focusing on school to pipeline practice and protecting the rights of all students to enroll in and attend school. Zoe was also policy counsel at DOJ, working on education and youth-related regulations and sub-regulatory guidance. And before that, she worked for various think tanks and youth justice organizations at the local, state, and national level, including working previously for SBLC on efforts to reform Alabama's juvenile justice system. She's published white papers in law journals on topics ranging from paid family leave to truancy reduction, and has given talks and forums across the country on issues from the impact of Alabama's 2011 immigration law on undocumented children to racially discriminatory school discipline as a modern-day vestige of segregation. She's a graduate of Harvard College and the Berkeley School of Law. And so we'll turn it over to Zoe, who will be talking more from the government approach to this pandemic, and then we'll have a chance for a conversation and questions.
Thank you.
Oh, and share screen.
How is my volume, Jamie? Is it all right?
I can hear you. I'm not sure if I've managed to share your screen though. Have I managed to share your screen?
I believe so.
Okay, excellent.
So I will note a couple of quick things to everyone. First, my PowerPoint is very short. It is not nearly as impressive as my brilliant co-panelists. So don't worry about any extensive note-taking from the PowerPoint. And then I will also just note that it is possible that you will hear yowls from my cats, Thurgood Marshall and Harry Blackman. If you do, that's normal. So the joys of Zoom presentation. So with that said, let's talk about local government. And Jamie, can I bother you to go to the next slide? Cool, that's literally it for everyone. So thank you in advance. So you may be thinking that this is the least exciting topic today, but I promise it will be worth your time to talk a little bit about local government law. Local government is where the rubber of the law meets the road of operationalizing public policy. And I promise that that is the last stretched thin cliche I will use in the next few minutes. So let's get started. The first thing that I want to talk about is, what is a city? So a city is a municipal corporation, and we'll talk a whole bunch more about that as we go forward. The second thing we're going to cover is, what is a county? And a county is a political subdivision of the state. That difference actually gives cities and counties very different roles and responsibilities, and it makes them very different kinds of legal entities. So you may be wondering, why in the world am I going to ask you to listen to me talk about the legal differences between cities and counties? And the answer to that is that understanding both the similarities and the differences between these different forms of local government is absolutely vital from my perspective to understanding the challenges and opportunities of responding to a public health crisis like the one we're in today, and especially with respect to responding to our most at-need neighbors, unsheltered homeless folks. And so the terminology, I should note, I defer to my fellow panelists on using unhoused versus homeless. We generally use homeless in our local regulations and ordinances in Oakland, so that's the terminology that I'm using, but I believe that we mean the same thing when we're talking about that. But very happy to discuss that more later. And so the other reason why I'm going to take some of your time this morning to talk about local government is that when any of us say this service needs to be provided or that change in policy needs to be made, it's incredibly important to know which legal entity or which entities actually have the power to make the change you want to see happen. So let's start a bit with the legal history of cities in California. And I should note that as a caveat in discussing the history of California, because we are limited on time, I'm going to note but set aside the actual history of the state of California that, for instance, recognizes that our land was long inhabited by Native communities well before its entrance to the Union, that it was actually Mexico, etc. So acknowledging those facts, but that is not the subject of today's talk. So noting and then setting aside for the moment. But in any event, California became a state in 1850, which is the year after it finalized its first constitution. So in the Constitution of 1849, the legislature actually had the power to establish cities and had the sole power to establish cities. And then also delegated itself the power to give cities what power they were allowed to exercise. So legislative authority over the creation of cities and what cities were allowed to do was paramount. That did not go so great. So by 1879, cities were pretty sick of the state meddling in their affairs. So they threw a new constitutional convention, the Constitutional Convention of 1879, where we, in our great wisdom, decided to borrow ideas about home rule cities from the state of Missouri, of all places, and basically imported their language whole hog, and created a new state legal system that allowed communities to charter their own cities and also to grant inherent home rule to every city in the state. So that second piece applies whether or not the city is what's called a charter city or not. The California Constitution does allow cities and counties, regardless of their legal structure, to control and regulate a fair number of activities. But as a framework, it can be helpful to think about the post-1879 California city structure as cities having a sort of similar, though not identical, relationship to the state as states have to the federal government. You can think of it as a form of kind of municipal federalism. It's not identical, but there are similar issues like conflict of laws or preemption that do arise in the local state government contexts. But California was not done, of course. In 1896, there was yet another constitution written, and this one gave certain kinds of cities even more power than before. And so specifically, it made it so that a city's own charter, that is, a city can form itself and have a charter that it writes with its own local laws and policies. It made that charter a law of the state, so that a city chartering itself would get to pass its charter. And then with that passage, the city's charter has the same power as a legislative enactment, which is really quite fascinating when you think about it in terms of the relationship of local government law to state law. And so over time, there have been a number of additional changes made to allow cities to do things like run their own utilities, have their own public works organizations, and other things that are just necessary to effectuate local government law. But I'm sure it will shock all the lawyers listening right now that for over a century, charter cities and the state have been in an ongoing and perpetual legal scuffle over what is a, quote, municipal affair. That is the legal term of art. Those are the things that charter cities can regulate and ignore state law over. and then what is not a municipal affair and where state law is therefore still supreme. So today, all cities can make and enforce various laws and regulations that don't conflict with the state, but charter cities continue to have even more power over their own police, their own elections, their governance structure, etc. Oakland, where I work, is a charter city. It is one of 125 charter cities across the state of California. And for context, there are 478 incorporated cities in California, so there are a number of them that are charters, but they are not the majority. The majority are what are referred to as general law cities. So we now have some context for what a city is. So what is a county? There are 58 counties in the state of California, and they are the largest political subdivisions of the state itself, and the largest political subdivisions that have corporate powers. Like cities, counties also come in two flavors, general law and charter. And the difference between general law counties and charter counties is similar to how it works in cities. That said, no county has broad self-governance power because the point of a county is that it is the next level down from the state. Counties are political subdivisions. They're not like cities. And so the role of a county is to deliver services that are mandated by the state or mandated by the federal government. So those are services like health, welfare, criminal justice, etc. And just briefly, in terms of how counties function, they are separate governance bodies, typically run by a board. County boards are weird legal entities. They kind of get to be executive and legislative and quasi-judicial all at the same time, depending on what hat they're wearing. They have all kinds of powers, like when they put on their executive hat, they get to set priorities and oversee county departments. When the board puts on its legislative hat, it gets to adopt local ordinances. And when it puts on its quasi-judicial hat, it gets to do things like decide land use appeals that come before it. And then county boards also have other random powers, like being able to comment on civil grand jury findings. So I note those things to note just how different a county government is from a city government. And then the other thing to know is that there are county level officials who are only partially overseen by the county itself because, again, they are a political subdivision of the state. And so counties actually don't oversee some elected officials. For instance, a local district attorney is actually a quasi-state officer whose actual prosecutions are legally overseen by the attorney general. And similarly, a sheriff has a lot of different hats. A sheriff can be an officer of the state in enforcing state law, of the courts as an officer of the court, and of the county. So really depends on what they're doing that affects who supervises them. Alameda is a charter county, and I will note for those of us that live in the Bay Area, it is easy to get confused because San Francisco is weird. I can say that because I am from there, born and raised, but San Francisco is a geographically and legally contiguous city and county, so it makes it kind of a weird model. And I promise you that this is the slimmed down version of what is a local government. We are not going to talk about special districts. There are 4,763 of those in California, so a topic for another time. So let's take a quick look at what we've been discussing and focus in on our topic today, unhoused or homeless policy. And so when we are talking about homelessness, we're really talking about a number of vital policy questions that fall under this single umbrella heading. We might be talking about affordable housing, emergency shelter services, transition services, physical medicine, mental health services, public works, sanitation, supported employment, other employment services, food security, hunger, child-related services, childcare, education, transportation, policing. As my fellow panelists have already discussed, all of those things matter when we're talking about homelessness. And so when you're a local government, trying to figure out how all of those things work together is the challenge of addressing homelessness as a policy area. So some of these areas that we just described are municipal affairs. That was the legal term of art for the kinds of things that cities can regulate, especially when they're charter cities. So the kinds of municipal affairs that are mostly or wholly controlled and regulated and provided by a city are things like public works. And in Oakland, that is especially so, where we have plenty of our own local regulations on that front. There are other activities that are split between the city and county. For instance, law enforcement. So the city has its own police department and performs much of the law enforcement in our jurisdiction. But the sheriff's office is a county entity and is legally and functionally separate from the city and has its own policies, practices, and procedures that apply in Oakland as well. And so as an example of that divide, the city, for instance, does not run its own jail. The jail is the Santa Rita jail that is run by Alameda County and run by the sheriff's office. And then there are other activities that are so important to this question, but are really a county function. So as an example, the city of Oakland, like many cities, does not have its own public health department. The county operates the public health department, which means the county runs, among other things, communicable disease control. It runs diagnostic services, epidemiological investigation, isolation facilities, chronic disease services, etc. And so we've seen during the COVID crisis that it is the county public health department that's the legal entity issuing orders like shelter in place, about mask wearing, or about quarantine. Those aren't city orders. Those are county orders issued by the county public health officer. And the city of Oakland also does not have its own what's called a medical institutions department. That is also run by the county, and that provides inpatient and outpatient services. And then finally, Alameda County is the main funding recipient for a number of different types of federal assistance, including HUD funding, for instance, the Continuum of Care program. So when we think about the complex questions of how to provide services to our most at-need neighbors, the question of who is responsible for what is incredibly important and not simple. So just thinking briefly about one question that has been top of mind for many and has been widely reported on, which is getting folks into hotel rooms who need to be there for medical reasons. So thus far, the hotel rooms that have been leased in Alameda County to serve unsheltered folks who are positive with COVID-19, presumptive positive, or have a known exposure, those have not been leased by the city of Oakland. They've been leased by entities that have public health departments and can therefore run those programs, entities like the state or the county. And then figuring out who gets access to those programs requires referral criteria, public health investigators, people with PPE to perform field testing and things like that. And those again are public health professionals that typically work for the county as the provider of those services. And there are a number of other legal questions and policy questions that come through that lens that I'm happy to talk about more. And then as we think about each of those questions, I want to just note that each of those steps is legally vital and also tricky from a pragmatic perspective. Local governments are balancing complex civil rights questions, making decisions both as employers and as service providers. And the more that we learn from a variety of sources, from the CDC, from other public health entities, we have to continue to adjust our policies accordingly. And then the quick final thing I want to wrap up in a sec, because I know we are short on time. Just as a takeaway, I want to make sure to say that I suggest none of this is to suggest that anyone should stop advocating or that local governments should be given a pass now or ever. Legal rights matter more, not less, in moments of crisis. But the thing that I do want to suggest as someone who does represent a local government right now is that if you're seeing a problem and want to know why it isn't being fixed, some of the following might be useful to ask. So first, who has responsibility over the problem you've identified? One entity? Multiple entities? Does it require coordination across systems of government? What kind of local entities are you dealing with? Is it a weird hybrid like San Francisco or a city-county system? Are your counties and cities general law or charter? If they're charter, how does their charter differ from state law? Where would the funding come from to fix the problem we've identified? Is it Medicaid, HUD, CalFresh, a local service provided by local taxes? Is there a program in place to solve the problem we've identified and that program is just not funded or it's poorly run? Or is this an unregulated area that needs new programs and new policy overall? And then finally, who is the government stakeholder or stakeholders with the power to make the change? Can a single elected officer like a sheriff make it? Is it a staff level decision granted to a city administrator or city manager? Is it a decision that's left to elected officials? So those are the kinds of questions that I suggest might be useful in thinking about how to solve problems during the COVID crisis and going forward. Thank you very much.
Okay, great. Thank you so much, Zoe, and thank you so much to all three of the panelists. We'll move on to questions now, but I did just want to note that, as you can tell from their presentations, they're all experts in what they do, but they're all also really in the trenches right now working on responses to COVID. And so I'm really grateful for all of them for taking some time out of this really pressing advocacy and legal advice that they're working on to take some time to talk with us, and just really wanted to acknowledge the time is precious right now. And so I'm really grateful to all of you. We have a number of questions that I'll start with, and please, people who are attending, feel free to submit other questions. For the ones that we can't get to in the time that we have, we'll try to follow up with people if there's a way to preserve the questions. I think the first one is a general question, but I think it does relate to how cities could respond to COVID, and I know it's something that's being considered in San Francisco. Is a question: could a municipality satisfy the adequate alternative standard from Martin by providing a campground, or I'll just add to that, in Los Angeles, I think they're pursuing parking lots where people can set up their own tents. And so I'll open that to any of the panelists about whether that could be something that could satisfy Martin, or how we would go about thinking about that question.
This is Tristia. One of the things that I want to emphasize about Martin is that it was an as-applied challenge, as many of these Eighth Amendment challenges are. So whether or not an outdoor campground can satisfy the requirements of Martin is really going to depend a lot on the individual circumstances. There is language in the Martin decision about the alternatives needing to be indoor shelter. So certainly, one could point to that language to argue that an outdoor alternative is not sufficient. Having said that, there is also language that in the concurring opinion that the Martin decision applies when municipalities have made it unlawful to rest at all times in all places within that jurisdiction. So if there is a lawful place to be, then while it may not be indoor, there could be room for a court to find that it does not violate the Eighth Amendment, even under Martin. I point this out to say that, and I neglected to go over this during my initial presentation, but the Martin decision not only did Boise petition for rehearing en banc to the Ninth Circuit, which the Ninth Circuit declined to do, but they also petitioned the U.S. Supreme Court to review the decision. The U.S. Supreme Court also declined to review that decision. However, that does not mean that they will never take up this matter. There's a lot of strategic downside to testing the parameters of the Martin decision. It's not really a first resort legal argument, particularly where you have plaintiffs that may be able to meet their needs for resting in even an outdoor facility. Having said that, if you have people that are unable to meet their needs for rest because this is an as-applied challenge, as applied to their individual circumstances, that may not be an adequate alternative. So it's a very long way of saying it depends.
Great. Thanks, Tristia. Tom or Zoe, let me know if you have anything you'd like to add to that. Otherwise, we can move on to another question.
This is Tom. I don't think I have much more to add to that. I mean, just under kind of, for people with disabilities, you would also look at that under, is the space that's being provided accessible to people, on an individual case-by-case basis, and that would factor into the ADA or the availability of that designated space.
And I would just very briefly add, so I completely agree with what folks have said so far. The only thing that I would add is that when a municipality is considering a question like this, I would imagine that they would be asking questions as well about things like liability, and also whether whether the proposed camping space, for instance, would comply with CDC guidance, the guidances that Tristia was pointing to, which have some interesting guidelines in terms of not moving folks, in terms of the layout of camping spaces to allow for social distancing. And then it would matter very much, both based on what the CDC has stated and more generally on things like the ability to provide hygiene services and other necessary services to permit the kinds of life activities that we've been talking about today.
Great, thank you all. We'll move on to a related question. This is about vehicle habitation. So the question is about how cities along the West Coast, probably elsewhere, have had an increase in the number of people living in cars and RVs. And in response, we've seen lots of cities implementing bans on overnight parking or parking of oversized vehicles, RVs, that kind of thing. And so the question is, if unhoused people are using their vehicles as shelter alternatives to shelter in place, what is a good city policy? I'm paraphrasing a little bit, but would it be productive or counterproductive for cities to enforce parking bans and towing? And does Martin have anything to say about this in light of the current crisis?
This is Tristia again. The Martin decision came before we could anticipate the current global pandemic, but excuse me, sorry, my son just walked in the door. One moment, honey. The question, though, about vehicles as shelter is a great one. And it so happens that the Law Center, along with Disability Rights California, Disability Rights Advocates, Fish and Richardson, and other pro bono counsel, filed just last week a motion for temporary restraining order to prevent the city of San Diego from continuing to criminally punish people for seeking shelter in their vehicles under a vehicle habitation ordinance, and to stop ticketing and towing vehicles, including oversized vehicles, because the city also has a policy that makes it unlawful to park vehicles over a certain size every night between 2 and 6 a.m. And there's literally only one place that's inland that accepts RVs, and it's not appropriate for people with certain disabilities in general, and even less appropriate in light of the COVID-19 pandemic and the shared spaces that one would have to use if they're accessing the bathroom, for example, in that safe lot facility. So in terms of good policy, right now, when there are shelter-in-place orders that are necessary. We must follow them. The best science suggests that we must follow them in order to curb the spread of the deadly pandemic, and to allow us to lift the shelter-in-place order and resume normal economic and other activity. It makes very little sense from our perspective to punish people for using the private shelter that they do have, and even less sense to remove those private shelters from them without offering some sort of individual housing unit, something that's at least equivalent to the shelter that they have, which means that, a private place where they can shelter in place. And that's what that TRO seeks. And we believe that it's not only necessary as a matter of constitutional rights, and there we raise the state-created danger substantive due process claim, but is also necessary in order to comply with basic CDC guidance. And again, we point to the guidance with respect to unsheltered populations, where the CDC has been clear, do not break up encampments unless people can be offered individual housing units. And we think that same rationale applies to folks living in vehicles. One last point that I'll make is there are more and more people who are seeking out shelter in their vehicles for lack of any better alternative. And I didn't put it in my initial slides, but of the categories that the Law Center has studied since 2006, laws punishing living in vehicles are the single fastest growing category of criminalization law. So this is a really important issue, particularly in light of the pandemic.
And maybe I might just jump off of that and direct this to Zoe, to the extent you can speak of any efforts Oakland has taken since the pandemic and the declaration of emergency, relaxing parking restrictions in Oakland, and has that applied to like overnight parking and the types of vehicle habitation enforcement?
Sure, happy to share a little bit of what I can. So Oakland suspended most towing in light of the pandemic. The places where Oakland might still perform a tow, regardless of the size of the vehicle, would be if the vehicle is blocking essential services, blocking access to food delivery for Meals on Wheels or something like that. I should note that I don't have the information to share at this time on whether Oakland has actually towed anyone under that standard. We would provide, depending on the circumstance, either 72 or 96 hours of notice. And in general, the approach that the city takes would be to send folks from our outreach team to work with whoever is sheltering in a vehicle on moving away from an essential business or an essential government service or what have you, and would not resort to tow. So that is the general approach right now. I would also note that we the city, have several different what are referred to as safe RV lots or safe parking lots, where folks can park for months at a time and in that site have access to grounded power and hygiene services and things like that. So the combination of a very significant reduction in tows, ensuring that outreach is the first and primary response, and then having the safe RV lots are some of the ways in which the city's tried to be responsive at this time.
And I'll just add, there has been an effort to get some statewide guidance from Governor Newsom on towing during the pandemic. So if people are interested, I'll provide my email address at the end. I can send you some information, and everyone's welcome to call the governor's office and ask for some help at that level. Just a little pitch for my advocacy. I'm going to do two more questions for people who are still able to stay on. We've got one that I think goes probably to Tom. The question is to the extent that COVID-19 related disability triggers symptoms requiring an accommodation, does that provide a criminal defense for someone against quality of life offenses charged as crimes?
Well, I guess that depends. I'm not a criminal lawyer. I've not done criminal defense since law school, so I'm not really qualified to answer that in the context of criminal defense. The idea would be the idea is that it creates a request for an accommodation to enforcement of the law. But if you're already criminally charged, I don't actually have a good answer for whether it creates a defense to that enforcement, especially in a criminal proceeding. And I assume that that's more than just a trespass violation, but that's a difficult one. I would also defer to Tristia on that.
Whether it is or not is I don't know if that's something that can be answered generally. Quality of life offenses span the gamut. It may be that if a person has a disability that requires them to rest in areas where resting is prohibited, or that limits their access to whatever the alternatives to public space are for that person, then certainly it would be relevant to a defense and may be in fact a defense. But again, it would depend on a lot of specifics that we just can't know from a general question like that. Sorry for the unsatisfying answer.
Okay, I'll just throw out one more question. There were a handful of questions about San Francisco, and so that we'll take them a little bit together. Zoe was talking about the distinctions between cities and counties, and so one question is, what about a place like San Francisco that's both, and how that affects their ability to respond? And then as well, any thoughts about the impasse that seems to have evolved in San Francisco between the mayor and the board of supervisors regarding moving more unhoused people into hotels? I know that's a big issue. There's been a lot of coverage, and we don't have a lot of time, so I'm sorry for throwing out a big one, but any thoughts people have about the government issue, city counties together, and then what might be a way out of the impasse that seems to exist at the moment?
So jumping in regarding this is Tristia. Regarding San Francisco, just this morning, the Lawyers Committee for Civil Rights of the Bay Area, ACLU of Northern California, the Public Interest Law Project, and the Law Center sent a letter to Mayor London Breed demanding that the city comply with recent legislation from the county Board of Supervisors requiring the procurement of hotel and motel rooms for unhoused people as a critical public health response to the COVID-19 pandemic, and because of mandatory duties under the Welfare and Institutions Code, Section 17,000, which is a California state law. So in a nutshell, what's in that letter represents our thoughts about the impasse and what the city should do, both as a matter of good public policy, sensible governing, and as a matter of law.
Great. And Zoe, I don't know if you're able to provide any insight on the question about, is there a difference for the way San Francisco functions, given it's a city and a county combined?
Absolutely. So yeah, San Francisco, as noted, is legally weird. I don't think that's the actual term of art, but it's the one I'm going to use today. Because it is a combined city and county, it has this interesting hybrid form of government where the the Board of Supervisors is overseeing both county functions and city functions. There are some limited areas where they sit, where the county of San Francisco actually functions slightly differently than the city. Those are mostly in the education context and are very in the weeds of local government law. So anyone who's super excited about that, we can talk later. But in terms of advocates pushing on any county, whether it's San Francisco or elsewhere, it is helpful to think through, what's under control of the body sitting as a county government. So in San Francisco, again, that is both city and county. So for instance, San Francisco has its own public health department. So unlike Oakland, where Oakland is working with Alameda County, but they are separate legal entities with separate funding streams and separate governments and boards and functions and what have you. San Francisco, those are all combined. So there are some ways in which that is, of course, far likely has more of an ability to be nimble in responding, though I should note, I don't work for the city of San Francisco, and so have no insight into their internal deliberations or their deliberative process. But I think it is important to think through kind of what functions they can do as a combined legal entity. And then also, I will just note from the local government resource perspective that one of the benefits of being a separated city and county is that the city gets to use, its tax base, its revenue generation authority, its legal structures to perform city functions. And there's an entire separate entity that performs county functions. When you are a combined city and county that is geographically contiguous and getting all of its resources from that same geographic core, I would imagine, again, without any insight into their internal machinations, that there are probably some challenges to be running both a city and county system, presumably with not many times the number of staff members or resources that you would have if you added up Oakland's city resources and Alameda County's resources. So just some things to think about in how and whether and on which buttons you push.
Okay, great. Thank you, Zoe. We'll wrap up here. I first of all just wanted to thank all the participants. There's a lot of you and you all stuck around for quite a while. So thank you so much for attending and for the great questions. And again, my big thanks to the panelists and to excellent technical support from Jake. And I have one announcement for the At-Large Chapter, which is holding a virtual event on May 27th from 5 to 6 Eastern Time for discussion on whistleblowers with John Ty of Whistleblower Aid, called How to Help Clients Blow the Whistle Without Going to Jail. And so you can find more information about that at a link on the At-Large Lawyer Chapter for ACS. And I think with that, we will wrap up. Thank you all so much. I will provide my contact information after this. And if anyone has follow-up questions or would like to find out any more about ACS, you can reach me that way. So thank you so much, and we'll wrap up.